Start. Desertion is not the withdrawal from a place but from a state of things, for what the law seeks to enforce is the recognition and discharge of the common obligations of the married state. The state of things may usually be termed for short the home stop. There can be desertion without previous cohabitation by the parties or without the marriage having been consummated. Stop. The person who actually withdraws from cohabitation is not necessarily the deserting party. Stop. The fact that a husband makes an allowance to a wife whom he has abandoned is no answer to a charge of desertion. Stop. Stranger. For desertion to exist, there must be both the factum or physical separation and the animus deserendi or the intention to desert in the sense of bringing cohabitation to an end. Stop. For the offense of desertion, there must be two elements present on the side of the deserting spouse, namely the factum, that is the physical separation, and the animus deserendi, that is the intention to bring cohabitation permanently to an end, and two elements present on the side of the deserting spouse, namely absence of consent and absence of conduct reasonably causing the deserting spouse to form his intention to bring cohabitation to an end. Stop. Desertion is a question of fact, and so is the continuance of desertion. Stop. Though it is a question of law whether any particular conduct is reasonably capable of having the necessary deserting or expulsive meaning, desertion may be from certain acts in one case which in another would not justify the same interference. The acts draw their significance from the purpose with which they are done, as revealed by conduct or other expressions of intention. Stop. If a state of separation de facto exists during the relevant period, the primary question is whether or not that separation is attributable to an animus deserendi on the part of the respondent. Stop. Stranger. He has relied on Mullah Hindu Law 16th edition at para 442 on page 487 regarding marital duties, which means the wife is bound to live with her husband and to submit herself to his authority. Stop. The learned advocate for the appellant husband has also relied on the judgment of the Punjab and Haryana High Court in the case of Meena Rani versus Madan Lal, the obligation of the wife to live with her husband in his home and under his roof and protection is clear and unequivocal. Stop. It is only in the case of some distinct and specified marital misconduct on the part of the husband and not otherwise that Hindu law entitles the wife to live separately and claim maintenance. Therefore, stop.